Today, we are going to address another fundamental standard that one must meet in order for an invention to be patentable, and that is non-obviousness. So, we've already reviewed that a creation can't be the same as what has already been publicly disclosed. That is the novelty component of the patentability standards. But you have to understand that it would be really easy for anyone to see what's out there and just tweak it a little bit and then say, hey, what I've got is different, and so I should be able to get a patent on this. Thus, to account for this possibility, the patent laws require that the invention not only be novel, but it has to be a non-obvious improvement over what's already in public hands. In other words, what you have to show is that the invention is not merely an adaptation that would be obvious to somebody who's skilled in that field and understands the technology. So here, on this first slide, I have written down the essential language from the Patent Act, which prevents a person from obtaining a patent for an invention that would have been obvious to someone skilled in the art on the date the application is filed. The language is pretty much the same as it was before the America Invents Act, except that the pivotal day was changed from the invention date to the application date. So now, when you are looking for relevant, publicly disclosed information, sometimes called prior art, you need to zero in on what was in public hands on the date the patent was filed, asking whether the invention is different, and if so, whether those differences would have been obvious to one skilled in the art on that day. The million-dollar question is, what does it mean for an invention to be obvious in light of the prior art? How do you determine if something is obvious? Typically, a good place to start is to see if the Supreme Court has ever had anything to say about what the terms in a statute mean and how they should be applied. Here, the Supreme Court has spoken, but I have to tell you that it hasn't been all that helpful. Essentially, what the court has told us is that to determine if an invention is obvious, one must consider the scope and content of the prior art and how the invention differs from that prior art. Then, one must recognize the level of skill held by those involved in the field and whether they would have found the differences to be obvious, given what they know. So, I added the statement, "Say what?" because this doesn't help me one bit. It simply restates almost exactly what the statute says. So, I figure all I can do is try to pull together some items that might prove helpful if you ever need to convince an examiner or a judge that your invention would not have been obvious to one skilled in the art. And yes, I realize this is not rocket science. It's like proving obviousness with the arguments that seem, well, obvious. The first aspect that might prove helpful is if you can point to unexpected results. You know, like experts in the field thought that this was not possible, but voila, look what I achieved. For instance, you develop a glue compound that is significantly stronger than those in the field thought possible with available ingredients. It's like pointing to a wow factor to combat any notion that what you did is no big deal. You know, many times when you make an invention, what you actually do is incorporate several existing technologies to come up with something new. But since you pretty much are simply repackaging old stuff, you may have to convince skeptics that you did something more than simply pick and choose known components to reach an obvious solution in light of their individual properties. Your belief will be, sure, the stuff I used was out there scattered about for various applications, but nobody in this field ever thought to combine them as I did to solve the problem. And this will be the one focal point of the debate. The inventor will argue that experts haven't ever documented in any fashion that selecting and combining the technologies as he did might lead to an interesting solution. Those advocating that the invention is obvious will either produce such evidence or explain why experts in any event would have easily recognized the solution. Okay, so now I want to get to this item called objective factors, which are real-world circumstances that tend to support a conclusion that an invention is not obvious. Just to set the record straight, the Supreme Court has called these matters secondary considerations, on the theory that they might be used to support those primary factors listed on the previous slide. However, the Federal Circuit uses the term objective evidence, which symbolically elevates their importance. And since we are now talking about the real world, I can assure you that this kind of real-world evidence typically seals the deal when addressing non-obviousness. All right, on this slide, I listed several examples of objective evidence that might help demonstrate that an invention is not obvious to one skilled in the art. And when you think about objective evidence, I believe it is sometimes helpful to reframe the factor as a question that starts with the preamble, if this is so obvious, then why? And then you ask the question. It's like, if this is so obvious, then why have all these people that I've identified tried to solve the problem and failed? If the solution were so obvious, then why are so many companies throwing so much time and money at the problem to solve it? You can look at the factors in these terms also. For instance, how could this have been such a big problem for so long a time if the solution were so obvious? Why have inventors been focusing on a different kind of approach if this solution were so obvious? Look at my commercial success. How do you explain that if this were so obvious? Wouldn't others have already done it? Oh, and I put a sub-bullet here because you might hear a counter-argument that the sales were due to heavy marketing and not because the invention was so impressive. Okay, well, you get the idea. All right, so I want to spend some time on the Federal Circuit case Panduit versus Dennison. But before we get there, I want to point out that these debates about non-obviousness typically can arise at two different times. One is when your patent application is reviewed by a PTO examiner, and you have to convince her that she should issue the patent. Several kinds of objective evidence might be pertinent here. I'd say you conceivably might be able to dig up evidence on any of the first three on the list, perhaps the fourth. And that would be helpful in your negotiations to get the patent. The other factors, however, may not be relevant so early in the invention process. The other situation where debates about non-obviousness will arise is after the patent has been granted, when someone challenges the patent's validity by arguing that the examiner made a mistake. For instance, an alleged infringer might uncover prior art not reviewed by the examiner and argue that the patented invention was obvious in light of those additional items. Since this litigation may arise several years after operations have begun, there may now be significant evidence regarding the commercial success of the product and how the alleged infringer behaved after the product was introduced. Thus, at this juncture, all of the items become potentially relevant. Okay, there I am. I'm kind of in the frame now. So, the disputed invention in Panduit versus Dennison was this cable tie, which is something I imagine you are all familiar with and take somewhat for granted. But back when it was first created, it was a very big deal. During the 1960s, Panduit began a research program to develop a strap that would be easy to tighten, but then hold tight so that it wouldn't unravel. You know how you sometimes take a rope to hold a bunch of things together, like pencils or steel rods, or, attach something to a gate, and then it never gets tight enough. And of course, it begins to untie, and everything falls out, and boom, there's just failure. So, this is a huge problem, and Panduit's founder, Jack Kavanagh, sought to solve it. So, after working on the problem for 8 or 9 years, Panduit came up with a solution in 1968, and he filed his first patent for the invention then. So here it is, by the way, and so it's got a head and it's got some teeth down here. And it's got this little ridge in here, and so you've got to put it in the right way. So the little teeth have to go here, and so you can. I'm trying to show it here. Pull it easily, right? And then you try to pull it apart and you can't do it. That's what it is. That's the invention. Okay? The patent examiner reviewed this invention, determined that it was novel and non-obvious, and so granted the patent in 1970. Another company then, Denison, began to work on a similar cable tie project in 1968. But after spending significant amounts of time and money, it failed with its own efforts, and so copied Panduit's invention in 1976. Denison soon became the second leading supplier of cable ties. Panduit sued Denison for patent infringement, and it was easy for it to demonstrate that Denison violated the claims in the patent. But Denison also argued that Panduit's patent was invalid because it was obvious to one skilled in the art when it was created. So this case is brought before a judge who sits on a district court, and he ultimately concludes that Denison was right. The invention was obvious, and thus the patent should not have been granted. Panduit appealed to the Federal Circuit, which hears all patent appeals. And this is the decision I assigned for you to read. Ultimately, the Federal Circuit reversed the trial judge's decision and ruled that the invention was a non-obvious improvement over the prior art. The case is very instructive because the Federal Circuit highlights a number of important considerations that the trial judge appraised incorrectly. In fact, the court's tone has a scolding bite to it, so much so that after several statements, I felt like adding a phrase such as, "You bozo." All right, I listed 4 of the issues that seriously troubled the Federal Circuit. There were more, but these are enough to consider for our purposes. Okay, so issue 1 goes something like this. Think of the judge picking up the cable tie and studying how it works. He goes, look, it has a lot of ridges or teeth on the strap, and they slide into a housing with a tongue that sticks back into them at an angle. I see. Hey, wow, that's easy, man. I could have thought of that. That seems pretty obvious to me. So, this is what we call the problem of hindsight. And the appeals court thought that the trial judge fell victim to it. Basically, the issue is that once you've seen a solution and how something works, it's hard to put yourself back in time and then evaluate the invention from the vantage point of someone who hasn't even seen it yet. But you have to be careful to do that. To evaluate the invention as someone skilled in the art who is thinking about the problem on the date that the application was filed. Unfortunately, the trial judge did not meet this responsibility. Instead, he learned the solution from seeing the invention, and then used that information against the inventor. You bozo! Next on the list is an instruction to evaluate the invention as a whole when addressing non-obviousness. So, when inventors develop new products, it is fairly common for them to use existing technologies and processes, but then assemble them in some unique fashion to create a different result. And this was the case with Panduit's cable tie. As required, when the judge evaluated Panduit's invention, he reviewed it in light of the publicly disclosed prior art to determine if it was novel and non-obvious. In this regard, there were several previous disclosures about straps with teeth, ledges to absorb forces, and flexible hinges. What the judge did wrong is that he compared the components individually, piece by piece, rather than looking at the invention as a whole. Thus, he compared Panduit's strap and its multiple teeth with previous disclosures about straps and teeth, and the judge found Panduit's use to be obvious. He took the same approach with the ledges and the hinges, finding each separately to be obvious in light of the related prior art. However, Panduit's patented innovation was not directed to the individual components, but rather to the novel way that they were selected and combined to create the beneficial result. And this judge just did not adequately appraise this. You bozo! In this case, the Federal Circuit also illustrated the importance of objective evidence to prove that an invention is not obvious. The following factors certainly helped to persuade the court that Panduit's invention met the standard. Both inventors, among several others, spent years and huge sums of money in their attempts to tackle this problem. Indeed, Denison, after making these investments, abandoned its efforts and simply copied Panduit's invention. Also, the invention was a substantial success. It quickly became the industry-leading device and generated sales of $50 million per year. I have to tell you, back then, that was a lot of money. And these sales were not a consequence of unusual marketing practices or for some other reason not related to the invention. Given all this, the objective evidence, the real-life story, strongly supported the conclusion that the patent was valid. How could you not see this? You bozo! Oh, just while I'm doing this, just as an aside, here's an item that I didn't list. The trial judge said the invention was obvious because it could be easily explained by general principles of physics. The appeals court basically responded by saying something like, are you really saying that inventions must defy natural laws to meet patent standards? Oh, come on, you bozo! All right, back to the PowerPoints a little bit. I placed deference to decisions of the PTO last because it provides a lesson that will be important when we consider the procedures for obtaining a patent, something we're going to do next. The starting point here is that patents are presumed valid, which means that Denison had the burden to prove that the PTO examiner made a mistake. To do this, Denison showed the judge the prior art and argued that the invention was obvious in light of it. The trial judge behaved something like this. He went like, ah! He really did that sort of a whining voice. I don't know. I keep going back and forth on whether this thing is obvious or not. All right, so you have to understand that this judge is not an engineer or has any real technical expertise in the field. He's probably a lawyer who became a judge without specific training in any relevant technologies. On the other hand, patent examiners do have appropriate backgrounds based on technical degrees or other factors. Therefore, one might expect them to better understand the invention from the perspective of somebody skilled in the art. So the situation here is that the patent examiner, who is the technical expert, determined that the invention was non-obvious. The judge looked at the same evidence of prior disclosures, couldn't make up his mind, and then ultimately overruled the examiner's decision with his own appraisal. I mean, really, that's pretty arrogant. Without finding that the examiner had made some clear error, he should have deferred to what the expert had concluded. End of story, you bozo! So, here's the message I want you to understand. The judge is supposed to defer to the technical expertise of the patent examiner. This is especially true when the judge is evaluating the invention in light of the same prior art disclosures as the examiner reviewed. However, consider how things might be different if Dennison had uncovered evidence of prior art that the patent examiner had not seen. Essentially, Dennison would now be saying, "Look, Judge, I respect the patent examiner, but here's stuff he didn't review. And if he had, I'm sure the examiner would have ruled that this invention was obvious." You know, that argument kind of works for me. Frankly, if I were the judge, I might then pause and say, I think you're right. I need to consider this a little more closely with my own eyes. So, putting this together, what it means is that if the patent examiner has previously reviewed all the relevant evidence, then if the patent is challenged, the judges will defer to the PTO's decision about the patent's validity. However, if the alleged infringer, or whoever, finds prior art not seen by the examiner, then this opens the door for judges to make their own independent evaluations and find the inventions to be obvious. So I just want you to start thinking what all this means when you consider conducting a patent search for the application. The more public disclosures you uncover, the greater are the odds that the examiner will find certain aspects of your invention to be obvious. On the other hand, the more the examiner has reviewed, the greater will be your confidence that the approved patent claims will hold up if the patent is ever challenged. As we're going to see, the choice will be yours, but patent lawyers often believe that the benefits from certainty outweigh those from weak patent claims. Okay, that's it for the non-obviousness standard. Next on the agenda are some of the procedural aspects of getting and maintaining a patent, both in the US and abroad. Until then, I say goodbye and have a good one.